Good afternoon, friends. In our pursuit to bring speakers who can give insights on different perspectives and illuminate us with the knowledge, because as they say, knowledge is the best source of illuminating one's mind. And today's topic speaks volume regarding the knowledge which our speaker, Mr. KBS Sidhu, IAS, and a special Chief Secretary Punjab has. That is the interplay between Transfer of Property, Registration Act, and Stamp Act. After having discussions with Mr. Sidhu, though we shared and started sharing our knowledge process after being connected, though we were always connected through the Facebook, but more on these platforms, it has actually come out that knowledge can always be transferred through each other, but still you can retain that. And at the same time, once you're talking with each other, you can register the good thought processes. And one who is having good knowledge, like Mr. Sidhu, he can show a stamp on all what he speaks of. So the interplay between all these three things is the essence which I learned from Mr. Sidhu during all this time, that transfer of knowledge, stamping of the knowledge, and registration of the knowledge within the mind is an interplay which one learns and churns through. Talking in a different perspective, you need not talk on a topic in a right perspective in that way. But still, if you want to register something within the mind, it definitely gets registered for all times to come. Mr. Sidhu, as all those who have been connected, we all know that his decimation of knowledge on different platforms, Twitter, Facebook, and now of late his YouTube channel. It only reflects that he, as they say, one always finds an opportunity to give knowledge if one has. They say that even if you give persistent knowledge, and that's what I've seen in Mr. Sidhu's different talks on the Facebook, it's just like a flowing river, but you may not be able to catch it, but at least you can touch it and have the whiff of that. And since he has been, while an IAS officer assigning duties on land revenue, administration and urban development, he has the insights. Therefore, there was always topics, and also on the different platforms we had seen, invariably there was a talk regarding sometimes of Transfer of Property Act, Registration Act, or Stamp Act. We all knew as a lawyer and professionals that yes, there is an interplay. But what is the interplay? Can they be juxtaposed, or they have their own space within space, or they are wheels within wheels? These are all these small nitty-gritties which we will learn during this talk. And as Isha Khurana asked, can you please share the Facebook a link of live streaming? We will be sharing on the WhatsApp groups. So you can share. I can understand people are more interested to hear Mr. Sidhu. So I shouldn't be, as they say, I shouldn't detain all the participants from keep on listening to me, and they should have the insights from the man of the moment today. Over to you, sir.
Once again, I'm grateful to Beyond Law CLC, in particular, Mr. Vikas Chatrat. And he's introduced the topic beautifully, talking about registration, transfer, and stamping of knowledge. Luckily, knowledge is free, as Rabindranath Tagore said in his famous poem, except insofar as, of course, there could be intellectual property issues. But this evening, we are going to talk about these three statutes of the British era in the context of their intersection. The interplay would be obviously there in areas where they overlap. And that is when you're dealing with immovable property, and more particularly, transfer of immovable property. Otherwise, these statutes in themselves are so voluminous, they have so many facets, and there is such a huge lot of case law that I think that even if one were to speak on each and every statute separately, you would require 3-4 sessions, at least for one statute, to cover it up. But here the idea is then to have a laser sharp focus on, as if there were 3 circles intersecting each other, like in a Venn diagram, friends who would have the elementary mathematics. So it is the intersection and the overlap that we are going to talk about. Registration Stamp Act 1899. They have objectives, yet they are going to be in force, in play when you transfer property, more particularly by sale. So what are the broad objectives of all of these? I think if one has to point out the odd man out, and that simplifies the equation, it is the Stamp Act. Stamp Act is basically a fiscal measure. It is essentially to raise revenue for the respective state government. It is a central law. The schedules prescribing rates can be amended by the state governments, and 100% of the stamp duty comes to the state government. So therefore, Stamp Act essentially is a fiscal measure. And whenever we want to understand any litigation connected with Stamp Act, even if it is in the context of a registered document, a registered sale deed which has been impounded, it is very clear that it has to be seen from the angle of a law which is taxing a person and raising revenues for the state government, like the income tax law and so on. So it is expropriatory in nature and hence construed strictly by the courts. Now, Registration Act and Stamp Act, someone long ago told me, they say they are so similar and yet so different. Registration Act deals with documents, whereas Transfer of Property Act deals with transactions. I think this is the fundamental and the most important difference that we need to appreciate. Registration Act comes into play if and only if there is a document. If there is no document, if some oral transactions are permitted and allowed, there is no question of the Registration Act 1908 coming into play. You want to sell a piece of ring, a gold to someone, it's a movable property, not compulsorily registrable. The Registration Act, and there is no document that you're signing, Registration Act does not come into play. Transfer of Property Act, on the other hand, talks in terms of transactions and transactions of immovable property. Transfer of Property Act is not per se applicable to states. They notify either in totality or particular sections. As the state of Punjab is concerned, we have progressively notified sale, mortgage, gifts, etc. under the Transfer of Property Act. Earlier whatsoever, and partition of any nature whatsoever, especially in the agricultural land, were not notified. Transfer of Property Act was not applicable to exchange of rural agricultural land or partition of rural agricultural land by way of oral transactions. In 1989, there was slight change that if the property sought to be transferred, at least one of them is an urban property, required a notification under the Transfer of Property Act was issued. So therefore, to begin with, rather than building up this as a climax, Stamp Act is a fiscal measure, Registration Act deals with documents, and Transfer of Property Act deals with transactions. So coming to the salient features of each, Registration Act talks about documents and what does it do? If any document has been executed between the parties, it is a private document. You could have a confidentiality agreement and it need not go into the public domain. So the fundamental objective of Registration Act is not to transfer the property. The fundamental objective of the Registration Act is to make a transaction, a deed, an instrument come in the public domain. Once you register such an instrument, and by way of caveat, I'm not talking about wills, and especially the wills which are deposited in the registrar or the deputy commissioner's office. They are an entirely different part of the Registration Act. We are talking this evening only of the immovable property, especially in the context of the sale. So therefore, the Registration Act makes those transactions public. More importantly, it lends a kind of simplicity to the transactions because the sub-registrar who's registering the document is satisfying himself regarding the identity of the persons executing. Now, in this day and age of Aadhaar cards and biometric identifications and so on, which many states have incorporated, including the state of Punjab, it is a simple thing to identify. People are being photographed in real time and those documents are being uploaded. But in the good old day, when the Lambardar or an advocate would identify the person executing the document, the registration would lend a very, very important presumption of authenticity to the transaction that had been entered to between the parties. So therefore, Registration Act hits the documents and it makes the documents public documents. So what does the Registration Act say? Section 17 of the Registration Act is the most fundamental one insofar as the transfer of property is concerned. They say if there is immovable property valued over rupees 100, then anything, it's very widely worded, anything which purports to create, assign, declare, limit, or extinguish right and property has to be registered. Now, here is the subtle point. Registration Act does not say that you must necessarily have a document to transfer property. All it is saying that if there is a document, then it must be registered. This is a question which is very commonly asked in our departmental examinations that, hey, you got this partition, memorandum of partition between brothers. It obviously extinguishes, creates, declares right, intercede the parties, intercede the co-sharers. So why it is not compulsorily registrable? This is also a very fundamental difference that we need to underscore and underline in the very beginning. It talks in terms of an instrument, a deed, which by way of its execution actually leads to the sale, exchange, gift, mortgage. In anything which creates, assigns, declares, limits, extinguishes, mortgage with possession, without possession, all those are part and parcel of the requirements of the Registration Act. Now, an instrument of partition and a memorandum of partition. These example I'll give you to illustrate the difference in the applicability of the Registration Act and the Transfer of Property Act. Now, if the brothers, three brothers, they want to divide their ancestral land, they sit together, they say this khabar, this khasra number is yours, yours, yours. Possession is delivered on the spot, and a memorandum of partition is merely a record of a transaction which already has been effected. It kind of post facto narrates what has happened. And on the basis of the same, you can actually go to and ask him to enter a mutation, which would be incorporated eventually into the revenue record. On the other hand, so therefore the memorandum of partition is not purporting to create, assign, declare, limit, or extinguish interest in immovable property. It is merely recording a transaction which already has been done. So that memorandum itself is not oral transaction, and memorandum is merely the record of an oral transaction which already has been effected. So therefore, this used to be the case in exchange also, and even today, at least in the state of Punjab, if you want to exchange something in agricultural land, and that exchange is something where the consideration is not wholly money. So therefore, actually, you can have an exchange where partly properties are being exchanged and partly financial or pecuniary consideration is there. But in same way, if you want to have an instrument of exchange, it will be registrable, the stamp duties issues will come in. But otherwise, you are in Taran, your brother is in Bathinda, you want to exchange property, equivalent value, no stamp duty, no registration at either place. It is an oral transaction. The brothers may reduce in writing a memorandum of partition to say, all right, this has been carried out. And it is always useful where you have these memorandum of partition, Khangi Taqseem, Khangi Tabadla, a private exchange. to immediately report to the Halka Patwari so that he can enter a mutation so that there is a record of the partition or exchange having been affected. In fact, under the Land Revenue Act, where we sit as Financial Commissioner Appeals and so on, and all the litigation connected with partition, one of the fundamental questions which is raised is that, all right, since 3 generations, sir, our private partition has taken place, although the ownership or the caveat is joint, but we are sitting in separate places. What if this caveat? Then the question immediately would arise that if it has been so, why did you not get it implemented? So that is an aside that if there should be any such oral transaction which has been effected, in respect of which a memorandum of exchange or partition has been done, it does not require to be compulsorily registered, well and good, but please do inform the Halka Patwari. Mutation would be sanctioned within the same village, and in case of exchange, if they are outside the revenue state, then 2 mutations of exchange would be entered and sanctioned, thereby kind of sanctifying into the revenue record that this transaction has taken place. Now, coming back to the Registration Act, when you register a document, let's say a sale deed, so you get a copy of the sale deed with beautifully embossed stamp and so on. These days we got e-stamping, and there is another copy which is stuck in the appropriate book of the sub-registrar. So that is a public document. So any person who wants to search the title for a particular village, for a particular revenue estate, for a particular property, then he's expected to go through this entire chain. And how does he go through? Because there is a copy in the revenue record already there. So therefore, it becomes a public document. And the point which I'm making is very important. I may not be able to quote the legal authority, but should there be, by any chance, a discrepancy between the copy that you've taken away and the one which is stuck in the office of the sub-registrar, then my understanding is that the copy which is there in the office of the sub-registrar, that the one which is, unless proven otherwise, to be the more authentic version of the transaction. So therefore, when you are actually executing a sale deed or any other deed, these are computer printed these days. Please go through word by word what you're getting. May have a khasra number missing in the copy which is stuck in the office of the sub-registrar, and civil litigation which is lengthy in nature can initiate, because ultimately the courts will rely upon whatever is the copy in the office of the sub-registrar. This is very important. This equally applies in case of registered wills, but that is a more dangerous territory which I'm not able to speak on with some degree of authority. Another thing which is very clear is that mere registration does not confer validity on a. For instance, you don't own the property, you get it registered. For instance, the person has died and you as sons are claiming, but he's left a will. Mere registration is not going to confer any validity whatsoever. So that would be a question of civil litigation. It would be, of course, evidence of a factum of a transaction. The transaction could be void, could be voidable, but mere registration would not confer validity on a transaction which is ab initio void. There are 2 other things. Again, I would request the friends to find the legal backing of these. What happens if under these 2 circumstances you go ahead with a particular sale deed? Of course, one is the property is under attachment by the orders of a competent court. In respect of that property, either a temporary or a permanent injunction has been issued by the appropriate court. Now, my understanding is that in case of attachment, and when you attach property, you enter a report into the Roznamcha of the Halka Patwari, the rapport number finds mention in the remarks column of the record of rights. But irrespective, if a particular property has been attached, sometimes there is no record of rights available in the urban areas, and the property is under attachment, any registered sale deed is null and void ab initio. It does not transfer the title. However, in case of injunction, if you do it, the parties entering into the transaction, as well as the sub-registrar, if he had the knowledge, could be open to the contempt of the court, but the transaction is not void per se. This is a very subtle point sometimes we deal with in our mutation proceedings. Another question which especially young IS officers, when they come and sometimes on the forums of the governance reform, citizen-centric land revenue administration, we talk, is, sir, why do you have to have a dual business? We rights of the Jamabandi is there, I'm reflected as the owner, and once that is there, automatically the revenue record by way of a mutation should be updated. Why do we have this double thing? First up, and he's harassed in the office of the sub-registrar, and then he's after the Halka Patwari to enter a mutation, and when the mutation is entered, then the Tahsildar or the Napsildar as the assistant collector grade 2 has to come and sanction. Some people can raise an objection and so on. Why don't we, when there is such a sanctity, why should we have this business of mutation being a separate proceeding under the Land Revenue Act? It is very important to understand that the objective of the two is very different. Under the Registration Act, what is being agreed upon and what binds is the two parties that have entered into the transaction. A is selling the property, B is buying. It does not bind a third party, a stranger is not bound by this transaction. On the other hand, although the recital could be there that you have passed on the title, the possession of the property, but whether it has actually passed on spot or not is something for the mutation proceedings to investigate and decide. So in mutation proceedings, it is not the transaction per se. In fact, the procedure is once a document is registered, Parcha Yadasht, a memorandum of registration goes to the Halka Patwari, even without the person proactively approaching, you have the facility of the mutation being entered. But mutations, sir, are to be decided in the open gathering of the village. You may have sold the property, but you may have entered into an agreement to sell with some other party. And that party may be in possession of that property, may raise an objection there, inherited from your father who's passed away, but your brother could be producing a will. So all these questions are answered in the proceedings which take place under the Land Revenue Act, distinct from the Registration Act, and there is a whole procedure of appeals and so on, up till Financial Commissioner, Revenue, powers of revision, and ultimately can also go to the High Court. Therefore, registration, yes, it binds you, but if you're talking about transfer of property, especially sale, please do not forget to get your mutation A entered, B sanctioned. There is a whole lot of, maybe a slight digression, but it is relevant at this point, whole lot of case law saying that mutation does not confer any title. It is merely the recognition of a title which is transferred. Very good theory. But sir, today you get a registered sale deed registered and you forget all about the mutation. Next record of rights is prepared. Your transaction has not been entered. The previous owner continues to be shown and reflected as the owner. Another 5 years passed. You may be in the possession of that property, but the same old owner who has actually alienated his property to you through a lawful valid document continues to be reflected as the owner. And tomorrow, the same Land Revenue Act, under which we say that mutation does not confer any right, under section 44 of the Land Revenue Act, it says that there is a presumption of truth to the entries standing in the record of rights, and especially when they're long standing. So therefore, fine, it is a fine legal nuance that mutation does not confer any title. If you are buying property and mutations in respect of that area are being entered and sanctioned, please do not leave it to chance. Please get the mutation sanctioned so that your ownership and your right is duly reflected there. Otherwise, the same person would be selling it off to another person on the basis of entry into the record of rights. He could be raising loans. Those could be fraudulent deals. Agreed. But then you would be the person getting into that civil litigation. Another point which I would like to emphasize, since I'm talking essentially on the intersection and also from the angle of a person who's dealing with property, the focus is less on our legal fraternity, but my focus of this talk is more on a person. And we in our individual capacity, apart from being professionals, would be buying and selling property at some point in time. So what is there regarding a sale to be effected or any transfer of property to be effected under the Registration Act qua a sub-registrar? The underlying fundamental principle, which is immutable, there can be a few exceptions. We are not here discussing those exceptions. A person necessarily appear before a sub-registrar once. And why I'm saying that? You could say, well, I'm not going to go, I'm going to give someone a power of attorney. Well, sir, your property is situated in Amritsar. You are situated in Chandigarh. You want to give a power of attorney to a member of your family, to an advocate, a trusted friend. You go here, your proof of address is here, fine. You will have to personally appear before the sub-registrar in Chandigarh for the registered power of attorney. A power of attorney duly registered in the office of the sub-registrar is the only one which can actually then be used by your attorney holder to get the instrument executed. In other words, attorneys, whether attested by a notary public, whether by a judicial magistrate, whether by an advocate, whether by an executive magistrate, as they deal with immovable property, insofar as they deal with eventually selling off of that alienation and permanent alienation of the immovable property, they have to be duly registered. So the underlying principle is that once you have to appear before the sub-registrar, irrespective whether you do so at the stage of execution of the power of attorney or whether you do so at the stage when you actually go in your personal capacity to execute that particular document. Now, we talked in terms of Transfer Property Act. We said that it hits at transactions. On the other hand, the Registration Act was hitting at documents. So one would say, what, sir, is there prohibiting me? After all, a sale, purchase of gold, of iron, movable property worth crores of rupees takes place. You receive the money through check, hand over the property, hand over the gold coins. You may enter into an agreement. Where is it written that if there is an oral transaction of sale, why should law have any problem? Registration Act is only hitting at documents. I've handed over the possession, I've taken my money, and if the person wants to get it registered into mutation and so on and so forth, it's his problem. But why should law? The law comes into play because the Transfer of Property Act says that these transactions, if notified, especially sale, I think it's section 54 of the Transfer of Property Act, gift, etc., so on and so forth, these require to be registered under the Registration Act. So the beauty is the Registration Act per se does not make a transaction of sale compulsorily registrable if there is an instrument. If there is an instrument, yes, section 17 of the Registration Act would apply. But an oral transaction qua sale, etc., is void ab initio. So if you people go, two people before the an apsildar or a tahsildar with mutation proceedings to say, sir, I have sold my property. I have received this payment through check and I have handed over the possession. Kindly sanction the mutation. The answer is no. This transaction is null and void and would be summarily rejected insofar as mutation proceedings are concerned. So we talked about the memorandum of exchange and we talked about the memorandum of partition initially by way of distinguishing the two. Cost of repetition, those memoranda are merely the record of oral that have already taken place. And if in the state in which you live, partition and exchange are not notified under the Transfer of Property Act, then oral transaction accompanied by a memorandum and followed by a mutation does not require registration. Therefore, there's no question of registration, stamp duties, etc. However, if you have an instrument of partition, if you have an instrument of exchange, then irrespective, you would have to have compulsorily registrable and stamp duty issues would also come in. Now, in order to enforce this registration, and there is similar provision in the Stamp Act, what is the effect of non-registration, or what is the effect of a particular document not being properly stamped? As I said, you have to put the Stamp Act through the lens of its being a fiscal measure. So therefore, if you are going to have documents and instruments which are not properly stamped, are unstamped, understamped, the sovereign revenues of the state government are suffering. If that is the case, then you still go ahead. You say, okay, I'm ready, I'm willing to take that risk. But tomorrow, if there is a dispute, kindly, sir, go through section 35 of the Stamp Act. It's very clear that any understamped or unstamped document will not be admissible as evidence. And the section is very, very widely worded. Not only courts, you have various quasi-judicial tribunals, and so forth. So the very objective for which you perhaps created that instrument would lose its value and purpose and objective because for a few thousand rupees on stamp duty, you could actually create a problem for yourself because that very document will not be admissible as evidence. Similarly, you got section 49 of the Registration Act. Something was compulsorily registrable by virtue of section 17. You say, I don't bother, he's my friend and we quite, believe and our word is, worth more than the paper this document is written on. But tomorrow if there is a dispute between you, your legal heirs, assignees and so on, section 49 very clearly says that this document, which is otherwise by law supposed to be compulsorily registered, then it would not be admissible as evidence of that transaction. Here the scope is slightly narrow in the sense it would not be admissible as evidence of that transaction, but for ancillary matters. For instance, if someone is wanting to produce what were his signatures in normal course of business or criminal litigation where you say this is authentic document and on the other side you some other signatures, to that extent non-registration would not be barred under section 49 for it to be admitted as evidence. But for the purpose for which it was executed, section 49's bar would come in. Therefore, if you are understamping or unstamping documents or not getting them registered, you're hit by the twin provision of the Stamp Act and 49 of the Registration Act, and those papers literally would be worth the paper that they are written on. Now, I've been talking about Stamp Act, and as I meander into Stamp Act, we talk in terms of its being understamped. Understamping is quite a simple type of a thing that, all right, this is, you say property worth 10 lakhs, if stamp duty is 5% ad valorem, it had to be 50,000 rupees and you've put only 14,000, it is case of understamping. And understamping immediately, it will be recovered. Registrar would perhaps not register it. And even if it does, that deficiency immediately can be recovered as areas of land revenue. The deficiency in the stamp duty is charged. The property could be sold 10 times. The charge, the sovereign dues remain on the property in question, and whosoever is the last person, he would suffer. Of course, enter into civil litigation to recover the said amount from the people from whom he purchased, etc., and so on and so forth. But understamped basically means that you admit the ostensible consideration as being the true consideration, and with the reference to the schedule and the rates prescribed under the Stamp Act, you have not put the appropriate amount of stamp duty. On the other hand, you have a process of undervaluation. Understamping and undervaluation. Undervaluation is that this property, this flat situated in Mahali, you are saying it is worth 1 crore. The sub-registrar says, "Mujhe dikhao ji, 1 crore mein kahan milta hai?" This is worth 3 crores. And therefore, it is undervalued. So two things are happening. Unaccounted money is getting into circulation. B, from Act perspective, the state government's dues are being eaten away. So now, in this day and age, we have got what are known as the collector rates and the circle rates for each and every area. Now, this is virtually a practice which is prevalent all over the country and has also been recognized under the Income Tax Act. The question of circle rates, the collector rates, which are revised for type of property, urban, institutional, residential, and also in terms of the superstructure. So if you present any document back, we are talking now in terms of undervaluation. You present a document before the sub-registrar. Now this is a beautiful interplay between the Stamp Act and the Registration Act. You present, and he has reasons to believe, especially on the basis of the collector rates, that the property is actually worth much more. And you are then getting it registered at a lower rate and thereby undervaluing the property and paying less stamp duty. The law is codified under Section 47A of the Stamp Act. The sub-registrar, in his own capacity, is to operate within the 4 corners of the Registration Act. He does so, registers the document. Your sale is complete technically, but the very same moment he impounds the document and refers it to the collector under the Stamp Act. The Deputy Commissioner is also the registrar under the Registration Act, but here it goes to the collector as collector under the Stamp Act. So the Deputy Commissioner as the collector or the Additional Deputy Commissioner as the collector under Section 47A of the Stamp Act will conduct a summary inquiry. You will have the opportunity of being heard. And if he passes a quasi-judicial reasoned order, and if it is found that the transaction was undervalued, then the deficiency in the stamp duty is recovered from you as areas of land revenue. In case of Punjab, this order was previously appealable before the district judge, but now it is appealable before the divisional commissioner. Another point under the Stamp Act, which sometimes is used, but very sparingly used, is the power of the Chief Controlling Revenue Authority, which in case of Punjab, the Financial Commissioner Revenue exercises those powers. Sometimes the documents are so complicated, contractual documents involving HU of property, partition, huge urban properties, family settlements, and so on. So one doesn't know, the poor sub-registrar or even the collector cannot determine as to what is the type of stamp duty that has to be charged. So the ultimate authority under the Stamp Act regarding what stamp duty, if any, is payable is codified under Section 56(2) of the Stamp Act. and the Chief Controlling Revenue Authority can exercise that power at the instance of the collector, or he can do so suo motu. But I can permit me to say that this power is not supposed to be a forum of second appeal in case of undervalued documents. So if you have a document which is undervalued, if you have a document which has been impounded, collector has charged his fees, the deficiency fee stamp duty has been ordered to be recovered, the division commissioner has dismissed your appeal. This 56(2) is not a forum of second appeal or revision. That is, in my opinion, the settled law. One thing which, now this is again a beautiful interplay between these three acts, and generally people in Delhi had kind of made it a business to avoid and evade stamp duty. So what was happening was, if the properties are valuable and even at a 5%, 10%, 11% type of stamp duty rates, people were saying, property worth 10 crores, why should I pay 1 crore to the state government? And the property dealers and unscrupulous dealers would say, sir, wo hai to Daryaganj ki ye property, but we have a way out, and this is what they would do. Have a power of attorney, which is supposed to be irrevocable, that you get from the seller, you take over possession, there is an agreement, written agreement, acknowledging the full and final payment of the sale transaction. You also transfer the property, and you also get them to have a will which is registered in favor of you or your spouse or your sons. So they would say, sir, these three triple documents, a power of attorney which is irrevocable, an agreement for selling full and final delivered with possession, and a registered will. What more do you want? Why do you want to get the whole thing registered and pay huge stamp duty to the state government? So this matter has been comprehensively settled by the Supreme Court in the year 2011 in the Suraj Lamps case versus state of Haryana. Of course, various state governments were also given notice and so on, and certain previous transactions of Delhi Development Authority where they had transferred the property on basis of such documents were saved. But in essence, what the Supreme Court is saying is that all these documents do not, in the eyes of law, when you read the Transfer of Property Act and the Registration Act and the Stamp Act, they do not convey the title. Power of attorney, the person continues to be the owner. You are merely the agent. Agreement to sell is only an agreement to sell. It is hit by the Transfer of Property Act and the Registration Act. So how does it transfer the title? Will, of course, will come into operation only and only when a person dies. It can be revoked at any time. So therefore, if you want to buy property, please do not try to save stamp duty. Try and get a proper, fully paid stamp duty registered so that you get full and complete title. Otherwise, going through these dubious documents of power of attorney, will, agreement, full and final possession, and even section, this is your 53A of the Transfer of Property Act. Time may not permit to go into that, where such a deal has taken place and possession has been transferred. Then section 53A, subject to certain conditions, does not even allow you to take back the possession, whether the person is saying, well, I'm trying to get the deal through and so on and so forth. So therefore, a sale deed has to be through a registered sale deed, fully stamp duty paid. There were also cases where collusive decrees were obtained and arbitration awards which were then registered and so on. Each and everything will lead to complications, and those complications will ultimately pass you on a defective title. So it's being, penny wise and pound foolish. So what Supreme Court has very clearly said is that any other instrument to convey title in immovable property over 100 rupees is not valid. Please go fully paid stamp duty and that is the way to go about. I would also like to underscore, underline, flag another kind of a practice which is emerging, and only on the 9th of July 2020, that's barely a month and a half ago, Supreme Court, I will leave the citation behind, in Dahiban versus Arvind Bhai Kalyanji Bhansali case, what used to happen is that, okay, you have a sale instrument, you receive some amount today, and the remaining and balance consideration, the person says, I'm paying through post-dated checks. Or he says, I promise to pay. Now, Section 54 of the Transfer of Property Act says, consideration paid, promised to be paid, partly promised to be paid. So till now, the law of the land was, sir, इसमें कोई खतरा नहीं, कोई रिस्क नहीं. आप रजिस्ट्री करवाइए, 10 करोड़ की आपकी ये डील है, उनके पास अगले 31 मार्च के बाद 1 नंबर में पैसा आ जाएगा. सो 5 करोड़ ये आ गया, ये करोड़ के जी 5 चेक हैं, month later post dated. And a person who's selling the property would say, hey, why should I do that? They say, sir, he's also added the interest portion, we are getting this thing. But, and what is the safety wall? वो कहते हैं जी अगर चेक बाउंस होगा, not only is he going to be prosecuted under the Negotiable Instruments Act, but more importantly, this transaction would be null and void, because the transaction, the sale consideration which he's reciting in the sale deed which is registered is actually not getting through. Now, this is a very, very important judgment of the Supreme Court which has come. It's only recently. They say irrespective of whether your checks get cleared or not, let's say the bounce, let's say he passes stop payment instructions, whatever, once you sell, that sale is complete for all intents and purposes. The person who is selling is left, the only remedy to do is to file a suit for possession. The transaction does not become, in any case, the transaction does not become null and void. So these two Supreme Court's authoritative judgments, and the second one was, I think, came at the right time because this practice was just beginning to emerge and balloon. And the other one, of course, was notorious in certain urban centers, including Ludhiana. So power of attorney, sales with possession and so on means nothing. And if you sell and there is a question of post-dated, then if those checks are dishonored, your sale is going to be as good as worth his paper in gold. A couple of things which are on the periphery of these three acts and would also impinge on us is the income tax considerations. This is very important because when you have a transaction, the algorithm, the computer-aided scrutiny, and all the faceless type of scrutiny which the Central Board of Direct Taxes has announced is always going to pick up transactions where huge sums have been, obviously a sale consideration being transferred. There is also a TDS beyond a certain limit. I think it was 30 lakhs earlier and now it's 50 lakh. That tax deduction at source is there. And if you say, you know, it's agriculture property and it is a capital asset, I was not subject to payment of any tax, please file your return and get the refund. But the thing which I'm going to highlight here is only this. If we talk in terms of undervaluation, what is undervaluation? Property is worth 5 crores. As per the collector rates, you are registering it at 3 crores. There is a differential of 2 crores. The state authorities will definitely recover that sum as stamp duty. The income tax department will have a twin attack on you. As far as the person who's selling, they will say for the purpose of capital gains, we are going to regard and substitute the consideration received by you, which you say is 3 crore with 5 crore, which is the collector rate. So you would be paying that tax, including penalty, interest, and so on and so forth. And on the other hand, the person who has bought a property ostensibly for 3 crores, when the circle rate or the collector rate is 5 crores, he would be regarded and deemed to be possessing unaccounted income of 2 crores. So therefore, you would have the person who's purchasing the property also getting income tax liabilities, including interest and penalties. So if you are selling rural property, this definition has been undergoing changes in the Income Tax Act. There used to be a huge schedule, so many kilometers from this area and that area. And in Punjab, where the municipal bodies are literally at every 5-10 kilometers, virtually the whole of the state of Punjab was covered by this. So now they have a notification, big municipal town, 10 kilometers, 8 kilometers, and 2 kilometers. If you are within those, then agricultural land is deemed to be a capital asset. You would be liable to pay the capital gains regarding that agricultural land as capital asset. So the advice to any person who's selling agricultural land, this is my personal advice, right at that stage, please take a certificate from the Tahsildar, the Nab Tahsildar, even a Halka Patwari, to say this property is situated in village so-and-so, Hadbus number so-and-so, is beyond 2 kilometers of municipal limits of Kurali as the crow flies. On Google Maps, you can actually, have a Google map, a snapshot of that. And with the beyond 8 kilometers of the Municipal Corporation of Chandigarh. And also, here is a Khasra Gurdwari which is saying wheat and paddy are being calculated. Tomorrow, income tax authorities could say, all right, sir, it was beyond the limits and therefore agricultural land, but was it being used for agricultural land? Aap uski wheat ki receipts laiye and so on and so forth. So therefore, if you are selling agricultural land anywhere, particularly in the state of Punjab and Haryana, it is my humble advice, please take a certificate of A, the distance from the municipal bodies which are nearest, and also in terms of the whether actually it was used for agricultural purposes. Something which I'd like to also add by way of a facility, there's a lot of litigation with reference to wills and so on. So Punjab government specifically has notified that transfer of property within blood relatives from father to son, father to daughter, to grandsons and granddaughters, both on the maternal and paternal side, those have been made free of stamp duty. So it is not my advice to a senior citizen to get rid of his property because tomorrow the sons and daughters may not bother for you. But this is an enabling provision that right while you are active in a sound disposing mind, you are giving away your property through a simple document which is called Tamleeknama, and no stamp duty whatsoever is payable. Nominal charges like rupees 1,500 or something, irrespective of the value, irrespective of whether the property is urban or rural. That is a facility which we can use, but use it discerningly with a sound disposing mind. And at least my advice would not be to squander entire property to your sons and daughters or grandchildren in your lifetime. You can always execute a testamentary document. So those are, of course, these transfer of properties within the Income Tax Act are also exempt from gift tax. But please, sometimes it is prudent to have 2 transactions from the sister to the brother and then brother giving to his child. That may be saving stamp duty through 2 transactions. Straight away going to the nephew, maternal, patija or panja may attract stamp duty in terms of a gift deed. So those type of things one has to be very careful. So in summary, we have these statutes. The interplay with the immovable property is built into it. On the periphery, there is also the Land Revenue Act. There is the question of mutations. At the same time, there are the income tax considerations. Then there are documents like relinquishment deeds, family partition, and so on. It would not be possible within the scope of this talk to get into all those documents. But I think, if you want to go through, it is always good to get the stamp duty in case of complicated instruments. There are asset reconstruction companies, there are surfacey companies. Now, one question which actually I leave it to the friends and legal fraternity here is, what, sir, is the liability on account of stamp duty where a civil court in execution of a decree, whatever the decree, a sale takes place in execution proceedings, and a registration is effected, a sale certificate is issued, and a person goes to the sub-registrar that, sir, stick this certificate, a copy of this certificate, sale certificate, money has been paid through the court, there is no question of undervaluation taking place, it was an open auction, the court has confirmed the auction. So you want to stick that into the official book of the sub-registrar, but the sub-registrar says pay stamp duty. In my opinion, there are divergent views. As lawyers, you may kind of explore this. As revenue authorities, we generally say, no, that is a separate matter. This is a sale certificate. They say the transaction, the transfer of title already has taken place. We would say a right for the title to be transferred has taken place, but please let's have stamp duty, and only then you would have this. Similarly, if you want decrees of civil court, there is also some fuzzy area that in case of a decree, especially when it is construed as a collusive decree, if you go straight away to the revenue officer, decrees of civil court are bound to be implemented in mutation proceedings. What are the stamp duty issues? There's a bit of gray area there, but definitely the sale certificates in case of your court conducted auctions, that is an area where at least I have not been able to find any authoritative ruling. So to summarize, these are three statutes: British era statutes, the Registration Act hitting at documents, the Transfer of Property Act hitting at transactions. You've got the Stamp Act, which is a fiscal measure, all come into interplay. There are power of attorneys and so on. And side by side, you have the Income Tax Act, which liability would also crop in. And one has to be very careful. And the cardinal principle is, at least if you are buying property, please get a full registered sale deed. I know there are cases like cooperative societies where you transfer a particular share certificate, a share certificate of a cooperative society gives you a notional ownership and right to use an apartment or a flat. And since a share certificate is a movable property, banks may be willing to lend. In Bombay and Delhi, it is a routine type of thing which is happening. Similarly, people having properties which are held by companies and closely held companies, they say, okay, share certificate register karwa dete hain, you save so much on stamp duty. Maybe you do, but there also you have to have those share certificates cannot be valued by virtue of the balance sheet. If the property you're holding, a huge property which was purchased in 1960, and in a closely held company, those share certificates have a face value of 2 lakhs, but that property has appreciated 1,000 times. Now, if you're going to transfer, you have to at least show that consideration, even if you're not paying the stamp duty. So all these mechanisms, strategies are there, but there is nothing like a neat and clean deal where you go through and have a fully paid registered stamp duty and due diligence. And one point which I missed out in case of undervaluation of section 47A, the limitation is 3 years. What normally happens is you get a particular document registered, you go home, and then an audit takes place. The CAG audit would take place after a year or so, the report would come, and after 4 years, you're getting a notice, hey, please give us this. Please give us this stamp duty, which is deficiency. Now, if that is the case, if it is beyond 3 years, it is time barred and you can reply to that notice accordingly. So these are, friends, the broad area of interplay. I'm sorry about the technical hitches. We'll try and improve that should we meet again. But this is something which, when you buy property, it is not often that you buy property. You should very easily pay the stamp duty so that the title is complete and you save yourself from litigation. Thank you very much. If there are questions, I would try to answer. If I'm not able to answer, I'll rather bounce it back to you, say, let the legal fraternity come out with those. So.
Right, sir. Thank you. The seminal topic of the interplay, etc., were nicely put across, and they were more practical. I was just thinking loud within my mind that we have done more than 140 webinars as on date, but we had been calling people like you to motivate us and legal aspects to be covered. But once we called you, I realized that the practical aspects which a common man suffers are also to be understood in the right perspective. Invariably, we will always go about the sections, etc. And sometimes the sections, etc. itself gives an mindset. It doesn't give the impetus in the right sense, but it sometimes gives the shivers that as to how to interpret, because every colon, every comma has its own interpretation. But practical aspects to be understood has its different dynamism to understand, and it seeps in better in the mind. And we have started getting questions, and we will take that. And that's the best way of knowledge sharing. We will also ask our friends that in case any question is coming, they can also post it on their answer or any citation if they know. Because as they said, as we always share on our platform, that knowledge is not only sharing, but it is another facet of caring. So if you intend to care for somebody, you have to share the knowledge, because even the gold, if kept in the closed wallets, will not have the true sheen. It only shines if you are actually showing it. The same way the knowledge, unless you don't show it, it is of no use. Rather, if we decimate knowledge, they say each one plant one. So let's take a pledge of planting a knowledge within the minds of everyone. This is by Radhesham. So what is the collateral purpose in case of an unregistered lease document brought before the court?
You see, but the collateral which is brought before the court, I think it is the person who's actually lending needs to get into that. My own thing is very clear, and that is what, when banks pledge and hypothecate, order hand and redemption of that, hypothecation without possession, each and every entry has to be through a registered document, and the mutation, or if not the mutation, the rapporteur Roznamcha saying that this legal charge has been created must be there. But if someone is taking a calculated risk as a lender, I'm saying you please deposit the documents and I will inform the Halka Patwari that these documents are with me and so on and so forth. That is his call. But ultimately, in the legal sense of the term, once you have an instrument, once you have a document, which section 17 says, which purports to create, assign, declare, limit or extinguish, and any pledging, hypothecation, collateral, etc. are all in that nature. To my mind, it must be through a registered document. But if the lender is taking a call, then in the event you default, it is his risk, because you could report that my document was lost, or you could take a certified copy of your registered sale deed and sell it off. After all, it is a collateral without possession. Then there would be criminal litigation, civil litigation, and so on. So as from a lender's perspective, from a banker's perspective, and if you see banks like HDFC Bank or financial institutions like HDFC, they are very, very careful and do their full due diligence. And that is why their recovery rates are 99%, as compared to the public sector banks where ye aage aaji personal guarantee le li, wo bade saab ki and all that. And there ultimately you find that the charge that has been created is not worth the paper it is written on. And in fact, we would be looking forward to this, the judgment of the Supreme Court, which is likely to come before Justice Mishra retires on the 3rd of September, as to whether the leased out spectrum, what happens when the company goes into litigation, liquidation. So whether it reverts back to the government and whether the person to whom it has been subleased, can you recover the AGR dues from that entity or not? But to answer the question in the legal sense, if you want to create a charge on immovable property, it has to be registered, and whatever nominal stamp duty in case of hypothecation and pledging without possession there must be paid. Otherwise, it is the risk of the lending or the lender.
Yes. So Abhishek, when a registry is challenged in a court and after 2 years of proceedings going on, if the patwari made an intikal on registry with indirect involvement of the defendants, what will be the time period of challenging the intikal, and will it be counted as contempt or not?
You see, it all depends on whether an injunction has been granted. The normal settled revenue law as far as mutations are concerned is that as long as the person is reflected as the owner and the possession has changed, we shall go by the registered sale. Fine. But if there is litigation, someone says, I had a prior agreement to sell, but irrespective of that, he's sold, either you get an injunction from the civil court and present it to the Halka Patwari and to the revenue officer who's to sanction the mutation. And to create a sense of responsibility, the instructions are that in case there is a contested mutation, like in this case, someone is relying on a registered sale deed and other one is contesting, saying that I had a prior agreement to sell and my suit for specific performance is actually pending, then it goes in for a contested mutation which only the subdivisional magistrate as assistant collector of first grade can hear. And of course, the entire appellate structure, collector, commissioner, and the financial commissioner. But if I were to be deciding a contested mutation case like this, where the registration has not been set aside, it is merely challenged, then what I would do is I would sanction the mutation in accordance with that. But at the same time, in the operative part of my order, also direct the Halka Patwari to enter the particulars of the litigation which is pending and put it in the remarks column of the record of rights, so that the public at large has an idea that there is some contingent liability attaching to that property. But unless and until a civil court actually sets aside and declares that registration deed as null and void, we are, as revenue officers, expected to go through with the same, provided the alienation is within your due share and the possession has passed on the spot. That is the law. Tomorrow, of course, if it is decided in your favor, you get a decree, a new mutation can be entered and reflecting you as the owner.
In that way, the ball will not be bounced back. The ball will be in the person on whose court he actually wants.
And because the mutation proceedings, historically, it's 1887's Act, what a mutation proceedings, summary in nature. What the Britishers wanted, from whom do we recover the land revenue? Of course, now, the whole idea was malkanda, you know, ownership. There is a sovereign liability to pay the land revenue to the crown. But now it is an evidence of a title, and therefore, if the civil courts decide, very good, you will have a new mutation in your favor.
So we have Sidhu Jain. We have unmuted him. He wants to ask a question directly.
Yeah, sure.
Yes, Sidhu.
Sir, good evening, sir.
हाँ जी, जान साहब की हाल है?
बस फाइन सर, ਤੁਸੀਂ ਸੁਣਾਓ ਠੀਕ ਹੈ ਸਰ ਪਿਟ?
हाँ जी, हाँ जी. ਤੁਸੀਂ ਮੈਂ ਪਹਿਲਾਂ ਵੀ ਪੁੱਛ ਲਿਓ ਕਿਉਂਕਿ ਉਹਦਾ ਮੈਨੂੰ ਜਵਾਬ ਨਹੀਂ ਆਉਂਦਾ. ਮੈਂ ਪੜ੍ਹ ਰਿਹਾ ਸੀ ਤੁਹਾਡਾ ਕਮੈਂਟ.
ਸਰ ਮੈਂ ਪਹਿਲਾਂ ਵੀ ਬਹੁਤ ਟਰਾਈ ਕੀਤਾ, ਮੈਂ ਨੈਟ ਤੋਂ ਵੀ ਗੂਗਲ ਤੋਂ ਵੀ ਟਰਾਈ ਕੀਤਾ ਸੀ ਸਰ, ਮਿਲ ਨਹੀਂ ਪਾਇਆ ਕੁਝ ਵੀ.
I mean, if I as a layman, I were to answer, or if I was sitting as the chief controlling revenue authority, he and I just all thought a relinquishment deed बारे.
जी जी. सर एक हो रहा है जी कि मेरे फैमिली ਦੇ ਵਿੱਚ
के बारे में अपना व्यू दे लेने दो जी. You obviously have a right, title, or interest in immovable property, which you want to relinquish in favor of someone. It is a valuable right, but you want to relinquish it. In my opinion, it is a case of a gift, not only from the stamp duty perspective, not only from a Transfer of Property Act perspective, not only from a Registration Act perspective, but also from a gift tax perspective or income tax perspective. So relinquishment deeds have to be seen as, of course, between brother and sister, relinquishment deed, no one is going to challenge. In any case, a gift from sister to the brother is not taxable. We have notified as exemption under the stamp duty itself. So therefore, it won't matter. But where you have a settlement with third parties, I think that any relinquishment deed has to be, and the nearest one to be equated would be a gift, and accordingly would be taxable both from the stamp duty perspective as well as from the income tax perspective.
Okay. ठीक है, thank you very much.
ਦੂਜਾ ਸਵਾਲ ਕਿਹੜਾ ਸੀ ਜੀ ਤੁਹਾਡਾ?
ਸਰ ਇੱਕ ਫੈਮਿਲੀ ਦੇ ਵਿੱਚ ਪਾਰਟੀਸ਼ਨ ਕਰ ਰਹੇ ਹਾਂ, ਖਾਨਗੀ ਤਕਸੀਮ ਜਿਸ ਤਰ੍ਹਾਂ ਅਸੀਂ ਕਰਦੇ ਹਾਂ, ਸਰ ਉਹਦੇ ਵਿੱਚ ਕੀ ਸਾਰੇ ਪਾਰਟਨਰਸ ਨੂੰ ਜਿੰਨੇ ਵੀ ਕੋ ਸ਼ੇਅਰਰ ਹੈ ਉਹਨਾਂ ਨੂੰ ਬਰਾਬਰ ਦਾ ਸ਼ੇਅਰ ਮਿਲਣਾ ਜ਼ਰੂਰੀ ਹੈ ਜਾਂ ਨਹੀਂ ਸਰ?
देखो जी, मेरे मुताबिक मिलना जरूरी नहीं है, because that is what the both in exchange and partition, it should be equitable, but it should not necessarily be equal. And you can actually say कि इन्ना पैसा जिहड़ा सी तुसी you have already paid, etc. And I think it should be equitable. Now, what has been happening in case of HU of partitions, and now at least in the case of Supreme Court's order, and a very sweeping order giving the daughters co-pastorality rights and the co-pastorality properties, which has, I mean, there was a beautiful webinar organized by Mr. Chatrat, very enlightening. So in that case, if the sisters are going to relinquish their rights and so on to defeat the very purpose, I think, somewhere or the other, those questions would be asked. Otherwise, normally the family partition would say कि जी वो हुआ तो शादी के वक्त उसे दे दिया था, and therefore everything is fine and brothers get and so on. I think it should be equitable but not equal. That is what my understanding is. Some gentleman was asking about RERA. I would also like to be enlightened under the Real Estate Regulatory Authority Act, the agreement to sell also has to be registered. Is that the case?
Under RERA, an agreement for sale is executed for a unit and registered. The sale is not executed. Would it be recognized as a legal document?
I think it is. Does the RERA Act make an agreement to sell compulsorily registrable? Is that the case? I don't think so. In fact, this has been my prescription to the political executive right from the day I joined service to this point, that to kill all type of litigation and all type of stamp duty matters, any sale or agreement to sell immovable property must be registrable, even if you put a 0% stamp duty, or you charge the stamp duty at that stage and say, in pursuance of that, if a registration takes place, there will be no stamp duty. But we have these agreements to sell. Sometimes they are discovered later on. The registration is at lower rates. You get into stamp duty undervaluation issues. 3 years limitation has passed. Income Tax Act is invoking separate proceedings, parallel proceedings. They are recovering their dues. We are recovering our dues. But if an agreement to sell under RERA is not compulsorily registrable and the person is not getting it registered, then of course the consumer courts and a suit for special performance, and also the complaint to the Real Estate Regulatory Authority that the particular builder is indulging this malpractice. Those are the type of things which are open to you.
So this is why we will take this last question of Vipul. He says, sir, since you have held the charge of financial commissioner in the recent past, we as a lawyers would like to know as how was your experience of holding court, and also those who may be considering of practicing on the revenue side. Could you please shed some light on the nature of advocacy involved and scope as a professional?
I think any young
webinar specific, but it is
I think Vipul Joshi is a bright and upcoming lawyer. I have had the occasion to run into him on a couple of occasions in professional capacity. In a couple of cases, I think he's appeared before me also. Any young professional who is practicing in the High Court and dealing with the land revenue matters, I would strongly recommend that he also starts delving into the financial commissioner courts. In fact, the litigation is so much, there is not only just one financial commissioner revenue, there are at least 7-8 other officers of additional chief secretary or the financial commissioner rank who've been given work under the Land Revenue and the Tenancy Act, including Lambadara cases, which can be very contested depending on the districts. Of course, as financial commissioner revenue under the vacuum property laws and other various laws where only specifically, for instance, the Chief Controlling Revenue Authority, then there the revenue officer has to the financial commissioner revenue himself must hear for the statewide. Now, to answer your question, the powers of revision in the Land Revenue Act, generally the partition cases and related to wills, both registered and unregistered, and sometimes for registration and so on. And of course, Lambadara cases where it's a matter of prestige rather than anything else. If you see the section 16 of the Land Revenue Act, the powers of the financial commissioner, I won't say are, almost like the writ jurisdiction of the High Court, but they are really very sweeping powers. You may call for this thing to examine the legality and pass any order that you deem fit. In many ways, even wider than the writ jurisdiction. But of course, the settled law is that, like in a writ jurisdiction, is there exercise of jurisdiction not vested by law? If there is some jurisdiction vested and that is not exercised, or there is a patent irregularity on the face of record, then the financial commissioner has to intervene. But my own sense is that all the cases at the financial commissioner level do not end there. If a person has gone in litigation right from an Absildar to a collector, subdivisional magistrate, commissioner, and financial commissioner, it will land up in the High Court itself. Now, to answer the other question, I think it's a nice environment. It may not have the facilities which our Honorable High Court has, but it is bang next. The dates and days are fixed, and generally the presiding officers are very accommodating, and notice, person replies, and it normally doesn't take long-winded litigation. So if you are into land revenue laws, then, and looking to defend by way of writ jurisdiction in the High Court, the corollary would be, and I have found there are many gentlemen who appeared before us, they are the same people who are also appearing in the High Court. So it is not as if once you built up that credibility at the level of the financial commissioner, generally, even if you lost the case, or even if you won the case, the other party has gone into the High Court, people generally would prefer to have the same counsel. So that is my take on it. And it also kind of prepares you a kind of a pre-engineering class for the High Court in that sense, insofar as the land laws are concerned.
So the points are well taken, which you have given us. Though the points which you have raised and given us, they are as bright as the sunshine, though it's otherwise that we are raining. Probably it's raining because the God is too happy that they have been enlightened, the people are enlightened at large, and the interplay, as what I said in the first brush when we started off with the webinar, that we are having webinars or books differently, but how to juxtapose and interplay all these complex issues in a 1 hour, it only reflects about the knowledge which you have and the way it can be put across. They say that the first to explain anything in life, maybe as a lawyer also, first you have to be clear on your thoughts. And when the thoughts are clear, then your actions are clear. And when your actions are clear, then you can also put it across in a much better way. So thank you, sir, the way you have been connected with us and have been sharing knowledge. Firstly, it was only your watch parties. And by watching you on those parties, at least we didn't enjoy with you, but we were always watching you on those Facebook lives. And that is why we have got connected. And we are happy that the lawyers and other professionals and public at large, not only of Punjab, Haryana, and with God's grace on Beyond Law CLC, we are having participants span India. And it's spreading like anything because people like you are helping to know the people that it's a good platform to enlighten yourselves. All these webinars are already uploaded on our YouTube channel, and this will also be uploaded on our Beyond Law CLC. Those who have not done so, they can like, share, and subscribe that channel for the updates, because they have 1 to 2 hours webinars, which gives you an insightful session and peep into this thing, and you will only see the lights across that. Over to you, sir. Last words from your side, and then we call it for the day. Tomorrow we will be having a webinar, just the last minute, on its post. I will just tell the exact title. Tomorrow's title is Protection of Women from Sexual Harassment, that is POSH, which is commonly known as, after Vishakha's judgment and so on. And we will be having, just like we had Interplay, tomorrow we will be having these POSH within the legal and corporate perspectives, because corporate want how to move forward. And the speakers are Ma'am Adilakshmi Logamurthy, those who have been in Madras. She's also conducting webinars like Beyond Law CLC. Their webinars are also well received. Along with her, it would be Rathi Naval Rajan, head HR of the Bale Beverages Packaging India. So do stay connected with us tomorrow at 4 p.m. And thank you for being stayed connected with us. Stay safe, stay healthy, and haste raho, gudgunate raho. Namaskar, sir.
Thank you very much.